Hi everyone and welcome back to the channel. I hope you all enjoyed my previous video. This week we're going to be looking at conflict avoidance and dispute resolution procedures in construction. This episode will cover how to set up a project to minimise the risk of conflict and disputes. So let's get into it. This competency covers the recognition, avoidance, management and resolution of disputes, involving an awareness of different dispute resolution procedures and an understanding of the application of dispute resolution procedures appropriate to the area and the jurisdiction of professional practice. In order to run a project to avoid both conflict and disputes, it is important to understand the difference between the two terms. Conflict occurs when there is a clash or incompatibility of interests between two parties. A dispute is something that arises as a result of conflict and refers to the justiciable side of things. So, let's look at conflict. In order to set up a project well to minimise the risk of conflict, you should: number one, use the tender documents to communicate exactly what is required by all parties. This could be reference to the contract that is being proposed at the time and what clauses that has in relation to dispute resolution, or reference to the code of conduct whilst working on site, etc. Number two, try to ensure effective communication between all parties. A common part of the project execution plan is the communication plan. This may be a few paragraphs explaining how communications are expected during the project, i.e. instructions will be via email or CA software, calls will be held via Teams, and so on. It will also touch on meeting schedules. This will ensure the team understand what is expected of them in terms of attendance and when, circling back to point number one. 3. Make sure everything is in writing. It is essential to ensure that all decisions and instructions are documented. This should be in email or digital document form. For example, if you're at a design meeting and the client makes a decision on something, this could be documented or minuted in order to proceed in the comfort that any conflict can be easily avoided if the decision is challenged. In this situation, meeting minutes would be used. Best practice with meeting minutes is to send them to all attendees after the meeting and request that they agree that they are an accurate and fair reflection of the meeting that took place. Number 4, follow company procedures and policies. Make sure to read and understand all of your company's policies, and if you're acting as a consultant or seconded to another company, you must understand their operating procedures and policies to ensure you are compliant with those. And last but not least, follow all RICS guidance, professional statements and practice note. Next we're going to look at recognising conflict and how to deal with conflict in a project. Initially, when a conflict arises, you should look to resolve it using communication and negotiation. If the issue is slightly bigger, you may need to call a meeting where all parties are present and negotiate a solution. Remember, this is just for minor conflict. If it's a dispute, it will need a dispute resolution procedure or alternative dispute resolution procedure. So what might cause a conflict or dispute on your project? Up first, commercial aspects. Conflict or dispute over costs will be the form of conflict that you'll experience. This is due to how costs are usually calculated independently throughout the project by both parties. And when it comes to final account, there's usually a negotiation to agree a final cost. Unclear or conflicting specifications or drawings. In complex projects, this can be a difficult task. Essentially, it's making sure all the building parts stick together, especially if there's elements of specialist design, or generally more than one or two designers on the project. This can lead to dispute, among other things, when it comes to constructing the design. Understanding this and good information, design and configuration management systems will help to ensure that this is avoided. Teams under pressure. This, although happens usually internally, isn't often an easy cause of conflict in a team. Understanding team roles, we could go into Belbin, but that should be a topic for another video, and personality types can often help teams work better together. However, if a bad decision is made or poor estimation of resource in a bid, for example, it is usually the team working on it that will pick up the pieces in the form of longer hours, and this can lead to conflict. Insufficient detail and consideration given to contracts prior to signing. There are a couple of elements to this one. If referring to a bespoke contract, it may be that dispute resolution clauses were neglected when it was being drafted, whereas standard building contracts have sets of clauses for this as standard. It may be that both or either of the parties didn't understand the dispute clauses, or didn't give it the correct level of consideration before signing. It's worth noting that in the HGRC Act, all contracts have a right to adjudication under common law. Unclear scope of service. And finally, as a point of note, you should always understand your scope of service. Most people don't think about it in their early career, I know I didn't, but it is essentially an agreement of what you do in return for your fee. Scope will vary in detail, format and formality in which it is agreed. In some cases, it might be vague, or there might be parts of it that are up for interpretation. and this can lead to conflict. So let's summarise a bit. How can you set up a project to avoid conflict and dispute? On top of what I've said earlier, the following 3 things should be considered when setting up a project. Number 1, open, honest, and transparent communication. As we have discussed earlier, avoiding conflict is about proactively taking steps to anticipate where conflict might occur. A lot of this hinges on good communication practices like getting everything in writing, getting everything agreed in writing, keeping detailed records and reports, and as best practice, always maintain your own conduct in line with the RICS ethics and professional standards. A lot of this relies on your team relationships. A culture of open and honest reporting should be established from the start. The team should communicate risks and issues and potential conflicts early and honestly. If this is done correctly, it will be a key trait of a successful project team. Number 2, partnering. Partnering theoretically is a general term that covers practices that are designed to promote greater cooperation. So what is partnering? It refers to 2 different businesses that share a common goal or numerous common goals that team up to achieve that goal or goals. Its fundamentals are built on collaboration, building relationships, minimizing conflict, and open communication. Adopting a partnering mentality or even a partnering contract, if suitable, can help to avoid conflict. So those 2 tips are really to avoid conflict, but what if there's a dispute on your project? Best practice would suggest that you have a sophisticated dispute escalation procedure agreed as amendments to the contract. This is to avoid one party in the contract skipping the intended flow of ADR and going straight to adjudication or arbitration under their common law rights. So let's look at some dispute escalation clauses. The RICS guidance note on conflict avoidance and dispute resolution procedures in construction recommends the following requirements to be in a contract. Service of a notice identifying and crystallising the issues in respect of the dispute that has arisen. The referral that dispute within a strict timescale for negotiation between senior managers of each organisation. If a settlement is not reached, again with a strict timescale, then negotiation should take place between the chief executives of both organisations, and the potential for mediation and arbitration or litigation in the court. Now it's important to note, as a project manager we cannot write these up ourselves, it must be done by a lawyer or a legal team. This is because of the limits to our professional indemnity insurance. We cannot draft letters of intent or amendments to contracts or anything like that. So it will take a legal team to draft up those principles into actual clauses. Great, that's all for today. Thank you very much for watching. As always, if you've got any feedback or you think I've missed anything, please leave a comment down below. And as always, if you enjoyed the video, consider giving it a like and subscribe if you would like to see more.